SJC-11344, Commonwealth versus Michael E. Hart.
Good morning. May it please the court, my name is Laura Banworth, and I represent the defendant, Michael Hart. This started out as a simple case when Michael Hart sought to vacate his plea for resisting arrest when he had not, in fact, resisted arrest. There was no factual basis to support the crime. Essentially, this was a case where no crime had been committed. A guilty plea should never have been accepted, and it should have been vacated. A Rule 30B motion was filed on the grounds that justice was not done.
Was there a colloquy of any sort at the time of the plea?
There was a brief colloquy that did not set forth the elements of the crime of resisting arrest.
Did his attorney report that he had explained the elements to the defendant?
He did, Your Honor, and this seems to be what the motion judge based his denial on, and also what the majority of the appeals court decided. They substituted the requirement that a plea be intelligently rendered. One of the ways to prove that is the defense attorney certifies that he's gone over the elements with his client. They substituted that for this other individual and distinct requirement that a factual basis for a plea needs to exist on the record. And here it did not. So, in essence, the appeals court has removed this requirement altogether, this requirement for a factual basis for a guilty plea. This requirement, however, appears in Rule 12c-5. A judge shall not accept a plea of guilty unless the judge is satisfied that there is a factual basis for the charge. This court has also interpreted that rule to mean that whether a defendant admits to the crime in open court or a factual basis is shown, a court may not convict unless there are sufficient facts on the record to establish each element of the offense. It's not enough for a defendant to choose to plead guilty to conduct that's not a crime. Due process requires for someone to be convicted that a crime must have occurred. Even on the back of the green sheet, the judge certifies, I have found a factual basis for the charge, and I have found that the facts relayed by the prosecution and admitted by the defendant would support a conviction for this charge. And I think it's worth noting that this certification is underneath a separate section on the green sheet where the judge says, I find that the defendant knowingly and intelligently and voluntarily waived his rights. They're separate, they're distinct, and they're both required. Since there needs to be this factual basis, we then move on.
Where's the green sheet in the record, by the way?
It's not, unfortunately.
I couldn't find it, okay.
It's not, unfortunately. But since there needs to be a factual basis, we then move on to whether one was established here on the record during the colloquy. Resisting arrest, as this court knows, requires that a defendant knowingly prevents a police officer from effecting an arrest by using or threatening to use force. There were no facts elicited that establishes these elements of the offense. Twice, the DA made the conclusory statement that the defendant resisted arrest.
A little bit.
A little bit. He even points out, you know, Judge, he didn't strike anybody. I'm not really sure exactly what he did to resist, but it says he interfered, so, and then the judge says, well, is he still willing to admit it? And the DA said yes, and the colloquy proceeded. And then again, there was a second section during the colloquy where more facts were elicited, equally unconvincing that anyone had resisted arrest. He was excited. They asked him to calm down. There was a crowd gathering. He disturbed the area. The police went to arrest him, and he resisted. This conclusory, unsupported...
What does the court then say to the defendant? You've heard those facts, Mr. Defendant. Do you have any questions with respect to them?
I think so, and I think he asked them if they are in fact true. But for this to be enough, for this recitation of facts to be enough, I think this court has to decide that the charge of resisting arrest, the entire charge, not just the elements of it, is self-explanatory. And this cannot be so. The appeals court relied on some dicta in the case of Tavernier that said that resisting arrest is, in any event, self-explanatory. But context is crucial. In that case, the charge was self-explanatory because there were facts elicited during the colloquy that established the elements. And in that case, there was evidence that there was a brief struggle. And all of the cases cited to by the majority in the appeals court and the Commonwealth about crimes that are self-explanatory, they're actually just talking about elements. I haven't located a single case where an entire crime is self-explanatory.
So what facts we know of is that the defendant showed up at his apartment, he found the police there, he was upset with that, he started to swear and make noise, is that basically it?
Correct.
And then the police told him to quiet down,
Or he would be subject to arrest.
and he didn't stop.
That's right. And it is worth noting that these are facts in the police report, which is another question. And I think, I think the rule requires there needs to be a factual basis on the record at the plea. I think for this court to find that that was met here, the court would need to find that resisting arrest is self-explanatory. I would certainly suggest that it's not, but should this court decide that it is, then we move on to those facts, Chief Justice, that you were talking about. Those are contained in the police report, which we supplemented the record with.
That wasn't actually produced at the time of the plea, is that what you're saying?
It was not produced at the time of the plea. It appears the ADA was summarizing from it, but that there were misstatements. I don't suggest that they were intentional or malicious, but that even when you look at the police report, it shows that no arrest occurred. There was nothing to resist it. So
No arrest
Basically, he
occurred?
was arrested.
I'm sorry, no arrest occurred at the time of the alleged resistance.
Oh, you mean all the swearing, all that stuff happened before he was physically arrested, is that?
Exactly. In the police report, it says he began yelling, "I don't like the police, you better not touch me." He continued to yell and swear and was subsequently placed under arrest. And none of the 3 arrest criteria were present at that time. There was no effecting of an arrest. It clearly says that it was subsequent.
So he was placed under arrest for yelling.
Maybe he was placed under arrest for disorderly, which he was also charged with. But essentially, yeah, he was not placed under arrest for anything other than words, which is certainly not any sort of threat or force. And there's certainly no evidence that he continued, even his belligerent behavior, his words, which were not very nice, after the arrest. So there was no seizure, and there was no way that this could have been understood that he was under arrest at this time.
Well, wait, the facts provided to the judge, very simple. When the police went to place him under arrest for this disturbing the peace or disorderly conduct, he resisted their arrest, right?
That's right.
They went to put him under arrest. He did something. He resisted arrest in some fashion. And
Right.
you're saying, well, we got to know, did he resist it by threatening to use force? Did he resist it by actually pushing the officer and not allowing the handcuffing to go on, or otherwise trying to?
I do think one of those facts would have had to have been elicited at the colloquy in order to meet the elements. Resisting arrest is not self-explanatory. What is it? Is it running away from an officer? We know that it's not. If the term was self-explanatory, I don't think this court and the appeals court would have decided so many cases within the last 10 years explaining what is and what isn't resisting arrest.
How explanatory does it need to be in a plea colloquy of this sort where he's told these are the facts. He's asked whether essentially he has any questions about those facts or whether they're true. The lawyer said he's explained all the elements to him, and the defendant agrees that they've all been explained to him. How much further does the judge have to go? Okay, I want to know specifically what it is that you did that you say was resistance. Is that what the judge needs to do?
Honestly, I don't think that's too much to ask. As busy as these district courts are, day in, day out, countless number of pleas, due process cannot be set aside for judicial
There was a lot of process
efficiency.
here. I mean, they went through a plea colloquy very carefully. He had counsel. So it's not that there was no process here.
There were no facts that established he committed the crime. The rule, the case law, it's distinct, it's separate from the requirement that a plea be intelligent. That's up to the defendant. That establishes the defendant's state of mind. There is this separate requirement that a judge, him or herself, must be satisfied that there is a factual basis for the charge.
So if the judge said here, I am satisfied that there's a factual basis for the charge, you'd say, well, that was wrong.
When did the discussion happen where the DA, I believe you were talking about this earlier, where the DA said, well, I can't really tell what happened, and I really don't know, but he's admitting to it. Or when did that happen in this context?
It happened at the very beginning of the colloquy. He said, I don't know exactly what he did to resist arrest, but he interfered with the police. So, and then I think at that point the judge said, well, he's still going to admit it.
Well, the court says he didn't strike anybody, did he?
That's right.
And the district attorney goes, no, he didn't strike anybody.
That's
So we
right.
know that there's not that element. He's not charged with striking anybody.
That's right.
Now, am I correct that your view would be different if this were a rape case and there was no specific reference to penetration?
I think Sherman says that it would be different. And again, Sherman, like all the other cases cited by the Commonwealth, have to do with a specific element, not an entire crime. In Sherman, and if you look at the facts elicited during the colloquy in Sherman, I agree with this court. It was clear that that penetration element, the sexual intercourse element, had been met based on the facts as elicited at that colloquy. What happened here, I think, is more similar to an appeals court case, Commonwealth versus Jones, where I think the defendant in that case simply pled guilty to the name of the charge. It was an assault and battery. I would submit that what happened here is no different than had the Commonwealth said on, docket number, Michael Hart committed the crime of resisting arrest by resisting arrest. That there were no other facts other than a conclusory, and it turns out, unsupported statement by the Commonwealth.
So what if it was assault? He committed the crime because he assaulted the police officer, right?
Well, I think we would still need
But
to...
you say, okay, we want to know details. What kind of assault? What happened? If there had been assault on a police officer, and and they said, well, he was arrested for a disorderly person, then he assaulted the police officer. All right, you've heard that, Mr. Defendant. Is that accurate? Yeah. Okay. No, not enough?
Maybe we're getting closer, but I'm not sure that it is. In fact, in Jones, it was the charge of assault and battery, and the court said that although it's entered common parlance, it's not readily understood. I do think, though, Justice Cody, that we're getting closer, but here we don't have anything like that.
But what about the context in which this whole incident occurred? It was inside his apartment?
It was outside of his apartment.
Okay, but they were in close quarters.
I
We're close together.
I believe so.
And they were talking to one another. There had been some yelling.
Yes.
And the defendant, this isn't a case, nobody's suggesting that he ran away.
No.
So we're talking about, I take it, something where the police officer went to arrest him and he resisted. I mean, isn't it enough that he just shrugged?
Well, we have no evidence that he did that. There was no evidence at the colloquy. There was nothing elicited that he did anything at all other than yell. And even when we look further to the police report, there was no evidence that he did anything other than interfere with the police. There's no force, there's no threat of force. He simply wasn't under arrest. He didn't resist it. There was nothing established during the plea colloquy to meet forth the elements of resisting arrest.
Well, the police officer said he went to arrest him and the defendant resisted, or the prosecutor
The
said that.
prosecutor did say that. But I'm not sure. I don't think that resist is a commonly understood term. I know the appeals court said that it is, but I don't think we have a good definition for resisting arrest. That's why we have all this case law. A few years ago, I might have thought that if a police officer stopped me and tried to talk to me and I ran away, I might have thought I was resisting arrest. But we know now that's not true. Resisting arrest has a legal meaning, and it's not self-explanatory.
Well, counsel, your time is up. We have to leave it there. Thank you very much.
Thank you very much.
Good morning, Your Honors.
Morning.
May it please the Court, William Connolly for the Commonwealth. Your Honors, we put this in context that at the plea colloquy, the judge was informed that defense counsel had explained the elements of the charge as well as the nature of the offense. So it applies not just to a generic A, B, C, these are the elements, and you know the elements, right? Okay, Your Honor, I told him the elements. He also told him the nature of the offense. The judge was also informed that that this defendant engaged in the conduct that he did. I think it occurred outside, actually, in a crowd, because a crowd had gathered at the time he was using abusive language and refused to come.
So let me interrupt you. So tell us, what did he do? What can we
We
conclude that he
specifically,
did? Yeah, what specific behavior?
there is nothing on the record, Your Honor, but there are 5 justices of the appeals court have considered the term resisting arrest to be self-explanatory.
Yeah, so we leave it with them?
No, but it's not a far-fetched notion that the words
3 of them.
resisting arrest.
3 of them. There was 2 in dissent.
Well, there were 2 in the Trevania case and 3 in the Hart case. That it's not a far-fetched notion that just the words resisting arrest carry a commonly understood meaning. And in this case, they did. Now, morphed into that is the fact that he is engaged in this particular type of conduct. And a disorderly person, probably most likely to be resisting arrest, but that's the category that he's in. And it's morphed into the charge of resisting arrest. And reasonable inferences are to be permitted when a judge is sitting there under Rule 12 wanting to know if there's a factual basis for the charge. He's entitled to, under this court's case in Jenna, to undertake reasonable inferences. With that, it's the Commonwealth's position that the judge was justified in accepting the plea.
What if the defendant had said, you're not going to arrest me, and he walked away and they grabbed him? Would that be resisting arrest?
Well, it's commonly understood that if he's engaging, he's opposing. And the appeals court lists various types of conduct, a dictionary definitions. If you oppose it, you strive, I don't have it at the moment,
What's
but
the answer to Justice Spina's question?
if he's resisting, he's not going to be arrested. He's expressed an
Walks
intent.
away.
He's absolutely, he's not going to, and he knows he's about to be, he's satisfying the 3 elements of Grandison, that he's understood he's about to be arrested or is in the process of effecting an arrest, and he takes actions to avoid that, yes.
Well, is there any of that in this record?
No, there's no, what I'm saying is there is no specific instance of what he did to resist. There is none. But it's the fact that he did
You're saying that
resist.
under 26, am I missing something? You just have to take some actions to avoid. The dictionary definition is okay. Any action to avoid. Not, you don't have to use threat or threatening or to use physical force or any other means which creates a substantial risk of causing bodily injury. That's not required.
That's far, in the resisting,
Yeah.
that would be, yes, that would.
So is it your view that it would be sufficient for a proffer by the Commonwealth to say, Your Honor, he was arrested and he resisted?
It has to be put in context, I think, Your Honor, as is it cannot be.
What's the context here that gives you more than that?
The context here is that he's engaged in conduct, disorderly conduct, at the time he's being arrested. And that's
But he's not guilty of resisting arrest if all that he did occurred before he was arrested.
But it morphs into that's the conduct that he's engaged in. So a reasonable inference would be that, yes, he did something during that period of time when he's being arrested to resist, because resisting arrest is explanatory. So I think that's I agree, you couldn't have it a naked state of facts. But I think this in this particular case, it's not a model for best practices. I acknowledge that. The Commonwealth acknowledges that. However, I think there's enough here to have warranted the judge's acceptance of the plea. Unless there's any further questions.
All right, thank you very much.